So, everybody, welcome to the second webinar in our series of Compliance in Practice. This series is designed to help business leaders tackle complex issues in the workplace with confidence. My name is Sean. I'm one of the solutions experts here at Citation Canada, and with me today is Kim Morris with our consulting team.
Thanks, Sean. I spent many years in HR at Citation Canada. After some time with the live HR advice team, I'm now the lead HR consultant with our consulting team. I work with employers nationwide, and we solve problems quickly and keep those workplaces running smoothly and compliantly.
Amazing. We're very lucky to have you today, Kim. Thank you so much. On today's webinar, we are going to be covering handling leave requests and accommodations in the workplace. Now, before we jump into all that, a quick introduction to Citation Canada for those of you that are here for the first time. We're a Canadian headquartered software company and service company specializing in HR and health and safety management and compliance. For over 15 years, we've been helping thousands of businesses across Canada keep their teams safe and engaged and set up for success. Our goal is to make it easier for organizations to navigate the complexities of compliance while building great workplaces. Just so everyone knows, we are recording and we will share out the recording after the webinar. And we have the chat open today and we encourage everyone to engage, but we are not going to be taking live questions. We can see that we got people coming from all over Canada today. We got people from North Bay, Toronto, Vancouver, Edmonton, Strathroy, Ontario. Amazing. People from everywhere, Regina. Amazing. People from all over Canada. So yeah, please keep engaging in the chat. Alex is there handling all that today. But what we're going to do now is we're going to start today off with a quick poll. If everyone could take a look at the screen here. The first question we're going to ask today is, when an employee asks for protected leave, where do you most need clarity? Figuring out if it qualifies as a protected leave, what proof to ask for, scheduling and coverage, or backfilling the role. And we'll give you a few moments to fill that in. All right. And we're going to cover all of this on today's webinar. We're very excited to talk about it. All right. Seems like we've got it a little bit weighted here. So the majority of you are looking for what proof to ask for. It's a great question. We're 100% going to cover that today. Then figuring out if it qualifies as protected leave, that's a tricky one. Scheduling and coverage and backfilling the role. All these things are really important. We're definitely going to cover it today. But I think what we'll do is we'll start with a very simple question on why did we choose these two topics, protected leaves and accommodation, for today's webinar?
Sure. These are frequent issues that we get calls from our members to our live advice. To handle them well, you need the right policy framework, compliant form, step-by-step process, and the access to experience and guidance when things get tricky, and that's what we offer.
Amazing. And since we're starting with protected leave, I guess a great question to start us off here is, what is a protected leave?
So figuring out if it qualifies as protected leave, we use the term protected and refers to its job protected time off under employment standards or labor standards, depending upon what they're called in your province. This can include time off related to pregnancy or parental, say, compassionate care or critical illness of a family member, to bereavement, short-term personal or personal illness or sick time. The protected means the employee's job is protected. That can mean that there cannot be no discipline for taking the leave, and broadly that they come back to the same or comparable role when that leave ends. Now, it's different from an ordinary attendance issue. We park discipline in this respect, and we follow the statutory process.
So does one size kind of fit all when it comes to protected leaves?
Well, the categories are similar across Canada, but the names, the lengths, the eligibility criteria, whether any portion is paid, what proof you can request, and the notice that needs to be given, that varies from province to territory. While the criteria are for being eligible is similar, the details aren't. The best practice is to have a simple chart for all the jurisdictions, say, that you operate in, and then a repeatable intake checklist.
Does an employee really refuse an employee's request for protected leave?
Short answer, no. It, I mean, if the leave is protected under employment standards and that employee meets the criteria for the leave, then in general, no, we can't refuse the request. The employee also can't be disciplined or disadvantaged in any way in the context of their employment for requesting to take a protected leave. An additional common follow-up question we have from that is, well, what if they don't get EI, or they're applying for EI, and how that connects with protected leaves as well.
It all gets really tricky because there's a lot of little nuance to all of this. You actually just mentioned EI though. Can you elaborate a little bit more on EI?
So the clarity I like to provide is the employee's entitlement to the protected leave under the employment standards comes from that, the standards or the labor standards, and it stands on its own. Now, EI benefits, those are administered by Service Canada, and that's a separate decision. An employee can be entitled to leave even if they are denied EI or they choose not to apply. As an employer, we confirm that the employee is entitled to the statutory leave, and we issue it ROE. That's a record of employment. That's what we're required to do by Service Canada. But then any eligibility is between the employee and Service Canada. We manage what time away is protected.
And so when it comes to attendance, there's different types of leave. You got your can't and your won't attend. Where does protected leave fit into that?
Where they are eligible and their criteria is clear, it's squarely in the can't attend. So it's not really automatic. This comes to our what can I ask for step in our poll. We can confirm the eligibility based on the criteria or the reasons under the standards. Sometimes it applies to employees' tenure. So pregnancy leave, for instance, the employee has to have been employed with you for 13 weeks before they're eligible. That the qualifying event or relationship, say it's a family leave, that they give the proper notice, although that's not a hard and fast in most cases. And then we can collect reasonable validation or proof tied to the leave, and also understanding the dates of the expected duration of absence. An example, family caregiver or compassionate leaves, depending upon where you live. Often employers can ask for a health practitioner's confirmation or certificate that the family member meets the criteria. Now, once those checks are met, we acknowledge that in writing, we set check-ins, return dates, including if it's an intermittent leave, and then we track our benefits and our records as required.
It's pretty tricky. It's important to make sure that you understand the type of leave that you're dealing with and that you're documenting it correctly. One of the things we can do here at Citation is we can help you with that documentation and with that advisory. Our clients have access to our specialists anytime from 8 a.m. to 6 p.m. Eastern to be able to call and just ask and discuss about this while getting great advisory on the back of it. Now, when it comes to things like this, though, what about pay and benefits? Do employers have to pay, keep benefits going, or allow time off on top of it?
Most protected leaves are unpaid as they're written in legislation. Job protection applies and benefits continuation, well, those rules vary, but most of the time they should be somewhere in place. Now, employees can stack leave. So, for example, the most frequent one is pregnancy goes right into parental leave. They could even combine vacation or paid days if it's allowed as well.
Oh, I get this question way too many times, but is this a decision that's made by legislation or by the business itself?
The way I'm going to phrase it is the employee may avail themselves of any paid time, not at the employer's decision. So an employer can assign vacation time with proper notice and process. But the employee can't be made to use their vacation time when the reasons for the absence is actually a protected leave.
Once again, it gets a little difficult. I can understand why so many of you are worried about what you can ask for and how. So if someone does go on protected leave and there is a need to hire someone to cover that role, how should that be handled internally?
Well, certainly a business can backfill to cover a gap. I would say key to keep in mind that the goal of the temporary coverage is to preserve job protection. If you hire externally, make sure that the offer clearly ties the assignment to the employee's return date so you're not boxing yourself in later. If you fill internally, say a secondment or an acting assignment, be clear it's time limited, both in the interim acting and the returning employee's same or comparable role as waiting. Don't promise permanency to the backfill and don't move the goalposts for that returning employee.
Makes a lot of sense. So what happens if an employee who is off work on leave decides they want to return to work earlier than planned?
Employees can't on protected leaves, they usually can return earlier than the date that they plan, provided they give the employer the required notice. Depending upon the type of leave taken, an employee should not be returning to work too early or past what the medical clearance says. And you can ask for documentation to say, okay, can this employee return to work before that original date and be ready to do so safely? What you ask for information will be varied by jurisdiction, but in general, you have to accommodate the employee's early return to work from leave. That's why we're back to when you are backfilling it, you're clear that it's time limited and based on the employee's return.
And so what are the risks to the business if they improperly handle a protected leave?
So one of my short answers and long answers. In short, mishandling of protected leave is expensive and it's avoidable. If you ignore employment standards rules, you can face orders from an officer, including administrative and monetary policies. Any discipline, dismissal, or reduction in hours that are linked to that leave can be tossed out, and an employer can be on the hook for reinstatement of employees plus lost wages and benefits. There's also the risk of being found to have applied reprisal or retaliation for the employee taking a protected leave, and that's its own offense. Many leaves can overlap with human rights, family status, pregnancy, sex, disability. So a misstep there can snowball into a human rights claim with damages. Weak notices or weak record keeping invites audits and broader inspections. Now, beyond those sides, the operational and the reputational to your business, they can mount pretty quickly. Union settings, you could have grievances. Your morale of your staff certainly can take a hit. And so these things added up could dwarf the cost of doing it right. Bottom line, treat the leaves as a minimum standards. Don't deny or delay. Don't cut benefits or penalize. Hold the job, maintain required benefits, and then document your decisions.
And honestly, there's so much more we could discuss when it comes to protected leaves. I see here in the chat we have some questions. I love that. Keep them coming. What we're actually going to do is put a link in the chat where you can book a meeting with myself and we can go into and have a nice conversation about some of the challenges you're dealing with and how we can help support you. Feel free to go in there at any time and set up a meeting with me. Those meetings with me are free to discuss how we can help you. But now that we've covered the legislative leaves, a lot of these things also trigger human rights accommodations, which brings us to the second half of our webinar and our next poll. So when an accommodation request comes in, where do you most want guidance? What can I ask for? What changes do I have to make and for how long? What if it's a safety sensitive job? And when is it okay to say we can't do that? We'll give you a few more seconds here to fill in the poll. Amazing. All right. Thank you all very much. This one's a little more spread out here. So about the majority, there's a pretty even balance here at the top between when is it okay to say we can't do that and what can I ask for? It seems to be a lot of things in the same realm of communication. What can I say to my employee? What can't I say? Then what changes do I have to make and for how long? And then there's some of you that are interested in what if it's a safety sensitive job. All of these are important things to keep in mind. But I think we'll jump into the first question when it comes to accommodation requests, which is, what do we mean by accommodation in the workplace?
I think we're definitely going to speak to all the points from the poll. Let's first clarify and set the stage. Accommodation is your duty as an employer under human rights, laws, codes, the legislation, to make reasonable changes to the work rules, duties, or schedules so an employee can do their job without discrimination up to the point of undue hardship. This would start when you know or should reasonably know that a protected ground is in play. The list of grounds vary by province and territory. Let's say they commonly include disability, family status, religion or creed, sex and pregnancy, age, gender identity and expression, race, color, ancestry, place or ethnic origin, and marital or civil status.
There's a lot of different ways that this can go when it comes to accommodation. And last time we spoke, you warned that getting accommodation wrong can get expensive fast. If it isn't a clear request from the employee, but there's signs that they do have a challenge, how should this be handled internally? And what's the right first move?
This may be the initial conversation or a point to what can I ask for? Let's start with awareness and a light touch. When a performance or attendance may hint at a protected ground, you have a duty to inquire. This means notice and ask gently, I'm noticing X. Do you need support or adjustments at work? Request only what's necessary, work-related, operational, or functional limits and expected duration. Like a quick one. I used to have an older child walk my child to school and they're not available for the next month. So I'm not going to be able to get here till 9:15 every morning for the next 4 weeks. That's absolutely reasonable. You got why it's related to work and the expected duration. We map that to essential duties. Okay, well, it's really, it's fine if you are here by 9:15. So let's try this. We keep it private, minimal, practical. Even without the magic words like an accommodation plan, we can't ignore these clear signs. So we ask, support, and then move forward.
And is a written accommodation policy required by law, or is it just considered good practice?
Not all provinces or territories mandate a standalone accommodation policy for private sector employers anyway. What is mandated everywhere is that there is a duty to accommodate under human rights, even if you don't have a policy. A couple of notable requirements here. In Ontario, under AODA, which is the Accessibility for Ontarians with Disabilities Act, many organizations must maintain written accessibility policies and multi-year plans. Now, this isn't the same as a human rights accommodation policy, but it certainly overlaps. Federally regulated employers, that's under the Accessible Canada Act, must publish accessibility plans and related processes, again, adjacent to accommodation, not a standalone accommodation policy. Our practical takeaway, even when it's not strictly related or required, having a clear accommodation policy and process is our best practice. And then it helps you prove that your duty to accommodate.
Honestly, it makes a lot of sense. One of the things that we can help companies do, and we help companies every day with things like this, is understanding the accommodation requests that they're dealing with in line with the legislation for their specific province. We'll be able to help you out with that and have the right documentation in place. Now, a lot of accommodations requests are illness related. When a formal plan is needed, where should you start and who should take the lead?
Notionally have the managers spot and stabilize the situation. However, you're going to want HR or leadership owning the plan. The starting points are simple. Confirm the essential duties, get functional information. And for clarity here, we cannot ask for the diagnosis, only the prognosis. We set temporary adjustments, review dates, and ensure to do a safety check. Key to keep it confidential and make clear that this is a living plan that you'll revisit. Where teams may often stumble, they ask for too much medical details instead of functional limitations or restrictions, then end up overpromising permanent changes, or worse, letting the conversation live only in a manager's inbox with no timelines or check-ins. And this is exactly how and where we can support with plain language templates, tracking dates, review dates, got our on-call advice, so that the leaders too can handle it consistently and defensively.
Can definitely help with that, but you actually mentioned something through there. I kind of emphasized it a little. Prognosis versus diagnosis. Can you expand on that a little bit?
We cannot ask for invasive private information with respect to the employee's medical history, the diagnosis. You can't say, what is the title of what's wrong with you? We can ask about the prognosis. That is what the employee can and cannot do and for how long. The goal is to understand their functional limitations in the context of their job and determine what reasonable accommodation is required, again, while respecting the employee's privacy. So, perfect example, when I'm advising clients, say, okay, your employee has indicated they can't do A, B, and C. So You ask them to have a functional abilities form, whether physical or cognitive. You don't determine which one, give them both forms. Give them a copy of their job description. The job description really should have the physical demands if it's going to be a physical limitation restriction. Have that completed by their healthcare provider. With that information, the employee and the employer, then you've got what's to be a participative collaboration on arriving at an accommodation plan that meets the limitations and restrictions while they're fulfilling the fundamental duties of their role.
Honestly, that's amazing. You probably have a million other stories in the same realm that you could probably go over. I don't know if we have enough time for all of those. But one of the things that we deal with a lot are people who are new to something like this. So for an employer who is new to dealing with accommodations or is just starting their business or has never had one happen before, what on a basic level should an accommodation plan cover?
Well, now we're at our polls. What changes do I have to make and for how long? Again, as I pointed out, the collaborative, this is a working agreement and it is always case by case. We started by identifying why we're accommodating the employee's specific needs as it was tied to a protected human rights ground. Then we set out what the job truly requires and the essential duties, looking at what the employee can and can't do right now based on that functional abilities form. From there, exploring options and choosing the best supports, again, keeping the person's dignity and full participation in mind. Now, this might be a temporary duty change, schedule tweak, or maybe additional devices or adjustments that makes the work doable for them. We write down these agreed to accommodations, not here's what we think is going to work. These are agreed to, how you'll implement them, make sure we're clear on who does what and by when. Include a clear review plan so you can check the effectiveness of it and adjust or escalate if necessary. Always keeping it confidential, plain language, and explicit that you'll revisit as needs or restrictions change.
And when someone is ready to come back, how do we phase them in without locking them into something permanent? And what changes if it's a safety sensitive job?
Yeah, it's interesting you said phase them in. Let's start with keep it temporary, specific, and reviewable. The idea of phasing in could mean a gradual return to work, maybe less hours, less days a week, decreased duties, light duties. Start with here's the functional, here's the essential duties. Have short time box steps with respect to those hours or tasks or tools with a clear review date. Now, in safety sensitive roles, let's make sure we add controls, additional duties so that the work is genuinely safe within that employee's stated limitations or restrictions. If it can't be made safe, we don't force it. HR notionally owns the plan, but managers implement and flag issues. So keep it all in plain language, keeping it private. Now, another point, I've supported clients where the employee, let's say they aren't attending as scheduled based on the accommodation plan, or they raise new limits that weren't in that functional abilities. Here, I treat that as a reset point. Let's check in promptly, ask for updated functional abilities information, and then amend the time or the plan if the limits have changed. However, if there's no new info that comes from this updated functional abilities form, let's say that supports these additional absences, and the expectations were very clear in that original plan, then we might have to look at this as being an attendance process. Either way, document. Look at the information you relied on and document the next review date.
So I feel like I'm getting a theme on the back of that one. Documenting things seems quite important when it comes to all this stuff. Hope that's fair to say.
Sure.
100%. Good. I guess one of the last questions I want to ask you here is, where is the legal line on accommodation? So like, how do we know when we've done enough and it's reasonable to stop?
I'm going to say from an HR perspective, an organization may not be able to accommodate an employee because doing so would cause undue hardship. That's the limit. Or it would interfere with what we call a bona fide occupational requirement. Now, undue hardship represents a limitation in how much hardship an organization must endure in this accommodation process. That undue hardship threshold is very high, and it's often difficult to substantiate such a claim. Organizations are expected to endure some hardship. It is important to remember that undue hardship can only be evaluated on a case-by-case basis. Generally, we can look at or what are often considered as health and safety considerations, outside sources of funding, or cost and financial consideration. There are some jurisdictions that may include additional factors. So in that case, you should consult with your jurisdiction's human rights legislation and legal counsel if necessary, if you're thinking you're at that threshold. Again, the organization has the onus or the responsibility to prove that this accommodation for the employee cannot be accomplished without the organization experiencing that undue hardship. Again, there is never a perfect accommodation, but there has to be reasonable efforts.
One of those things that we get questions on all the time. It's one of the things, it's one of our top 4 most popular questions when people call into our advisory about this sort of thing, because it can get so tricky. Businesses are always concerned. They want to support as much as they can, but they want to keep the business running. Honestly, thank you, Kim, so much. This kind of brings our accommodations piece full circle. Today's topics of protected leaves and accommodations are basically one of the most popular things that we get in our advisory line. Next up in our 3-part series, though, we'll be connecting the dots with workplace investigations and progressive discipline, how to handle complaints and fact-finding, what to document and when, and how, and to move into the discipline side of things. Just for everyone to know, once again, we will be sending out on the back of this the recording from today's webinar. We'll put the link one more time if we it seems like we already have. Thank you, Alex. If you would like to meet with us with myself for a quick chat, happy to do that. On behalf of Citation Canada, myself and Kim, thank you for spending the time with us today. Follow us on socials for the next webinar announcement and trusted HR and health and safety insights. We hope to see you at our next live session. Have a great rest of your day.